Moving on, I do have an email question concerning a jury trial, because if you're ever in a situation like that, when you're in a courtroom, you have questions. And this particular question comes from Steve, and he says, if my brother has an injury trial, can they ask him about involvement in any other matters like drugs or gangs? Is that a fair question to ask somebody?
It's an evidentiary question. Usually, if you're in we're talking about two different kinds of trials. There's criminal trials and civil trials. If you're in a civil trial and you have a felony conviction for something, yeah, it's pretty much fair game, especially if it's drugs or alcohol, and drugs or alcohol are issues in that case. Pre-existing medical conditions, or all kinds of things that can come into play. BJ, talk about some of them.
Yeah, well, what we typically do, Morgan, is before we go to a trial, before the trial starts, you've learned during the course of the case, there's certain evidence you don't like that may make your client look bad. It may confuse the issues. Just certain evidence you don't want for the jury to hear. And there's something called a motion in limine, which we use extensively. Well, we're asking the court right before the trial starts to exclude this evidence. So nobody ever gets to mention it in front of the jury in opening or during the presentation of the case, and it's out of the case if there's a valid basis to exclude it. Sometimes, like gangs and drugs, sometimes, like Carl says, sometimes that stuff might be relevant, but most of the time it's not going to be. And if it's not, it's best to get it excluded on the front end. And so we would typically file a motion in limine so the jury would never hear about it.
I like that.
During the trial.
I like it.
Well, the motion in limine is something that is put before the judge, which presupposes what the question will be. And then the court or the judge will look at it. And first of all, he'll decide whether or not it's relevant. If it's not relevant, it's not going to come in anyway. If it is relevant or marginally relevant, the court will then decide whether or not the prejudicial harm outweighs the evidentiary value and may rule it out then. On the other hand, if he deals that it is relevant to the case or any issue in the case or to the character of a party, the court may let it in. That's generally the way it works. I used to say that if anybody had a prior conviction of anything that involved moral turpitude, it would be relevant to go to the character if they were giving sworn testimony in that case.